Welcome back to Courtroom Uncovered. Today's case dives into the high-stakes world of digital forensics. The defense is pushing to introduce a brand new email forensics expert. But here's the twist. This witness wasn't brought in until just last week. That means the prosecution had little to no time to prepare for this new evidence. Think about it. A 15-page forensic report dropped just days before trial. Is this a brilliant strategy to shake up the case, or a risky move that could backfire with the judge? Stay with us, because this exchange is about to test the limits of fairness, cross-examination rights, and courtroom patience.
Can I respond here?
Yes.
Your Honor, we were able to locate an expert that's specifically an expert on email forensics in Microsoft Outlook, and we did not obtain that person until last week. And I did not have a report in my hands until Thursday evening, which I didn't read until the morning before I sent it on to the prosecutor. So this is a new witness, and I told the prosecutor that I don't know if we're going to call him because it depends on whether Detective Parvis is familiar and is able to answer my questions on the various indicators of this email that I want to get into. So, but if the court is not inclined, I won't. But I just want to be able to have the witness here in court to observe, since he might be required at the next level if it goes there.
But your questioning Detective Parvis is going to relate to that new report?
It is, but I'm not going to ask him about the report. I'm just going to ask him about the concepts, Your Honor, and ask him what he saw in the artifacts that he looked at in the server log and other places. So I'm just asking the information. I'm not going to show him the report or ask him about the report.
Well, I guess I'm at a bit of a loss as to how you're going to do that without referencing the report.
It's just concepts and things that Detective Parvis.
Right. Okay. I hear you, but are these new concepts?
Well, I haven't had.
And are they new concepts that one would have to prepare to address them in a form? I mean, part of my concern is, counsel, is that if you're going to do that, then Detective Parvis's testimony could be misconstrued in terms of his response.
I'm not sure what you mean.
Well, let's say there's something in the report that says something. I can imagine a circumstance where you ask the question, Detective Parvis answers the question based upon a certain understanding. That answer is then locked in. But then later on, there is this other really understanding that had that context been put on, there may have been a different response.
I don't intend to ask anything out of context. I intend to explain my questions and ask him about context,
but
what he saw and what he didn't see. That's all.
Right, but it's going to be, I get what you're saying, but the context of some of your questioning is going to be based upon the experts, your experts' analysis, right?
He told me about concepts and he told me what he saw and didn't see. I want to ask him what he saw, and I think I can question him about what.
Well, no. Your expert, well, just in terms of just what you just said, your expert told you about what he didn't see, what he did see, right?
I want to ask him if he saw those things.
Well, I get you, counsel,
okay.
But what I'm saying is your expert is giving you the framework for your questioning, right?
He didn't write my questions. He told me about concepts and what he saw. And
say that he wrote your questions.
But I don't even know.
That's not what I'm asking. what I'm at, you know, let's try it this way. You know to ask the questions that you're asking because of your expert's analysis. Nothing wrong with that, but that's how you know what questions and what areas to probe into. That's fair, right? I mean, because that happens with any,
I'm not an
right?
expert
Right.
in Outlook.
So if there's a report, a new report that just gets to the prosecutor, because well, let me back up. There was obviously a previous report, right?
Yes, Your Honor.
That then generated another report from Detective Parks, right?
That's correct, Your Honor.
Yeah, because that was the last part of the question.
Yes, yes.
Now there's going to be your questions to Detective Parvis based upon a new report.
This is where things really heat up. The judge is basically asking the key question on everyone's mind. Is it fair to allow brand new evidence this late in the game? The defense argues that they're only asking Detective Parvey about concepts, like what he observed in server logs, without directly referencing the report. But let's be real, every question is clearly framed by that new analysis. The prosecution is caught off guard, and the judge knows it. Imagine being asked to respond to a 15-page technical breakdown you've barely skimmed over the weekend. What do you think? Should late evidence like this be allowed, or does it cross the line into courtroom ambush?
And let me just ask this. I haven't seen the report or anything. Does that new report come to the same conclusions as your previous report?
Yes, but for different reasons.
Exactly. That's exactly what I was going to say. It comes to the same conclusion, but for different reasons. I think it would be highly unfair as we sit here today to, how long was this report?
I have a
I
copy.
think it's 15 pages, Your Honor.
Okay.
So the digital forensic report itself is 13 pages. Included with it was also the person's CV, as well as just a copy of an email correspondence.
And you're saying you just got this report
Thursday,
Thursday.
but evening, I believe. I'll double check. But again, we don't have to call the expert.
Right. But that's not the only issue, counsel. Part of the issue is you calling the expert. Part of the issue is, and I'm not saying anybody would be doing anything wrong, the way in which you frame the question, the context in which you're asking the question, which is going to be framed by, I would presume, that report. And then the response, the response to the question may have significant bearing. Let me strike that. The context of your question may mean something very different to Detective Parvitz, which may then guide his answer. And so what I don't want is I don't want responses that are going to then be misconstrued in some way, especially when we're talking about expert testimony.
Can I respond? So we have an expert on the stand an expert that presumably knows about the concepts I'm going to ask him about. I'm simply asking him about concepts such as, if you look at the server log, what was the source for the transmittal? Was it a certain type of source, or was it some other source? And I'm simply asking him what he observed. I don't know how this is unfair to an expert. And certainly if something is misconstrued or it needs to be clarified, the prosecutor can do that also.
Well, that's part of the problem. Certainly they could do that, but they've had the report for what, 3 days?
Got it almost at lunchtime on Friday. It's Tuesday, just about 2 o'clock. So no, I have not had time to read through it, Your Honor. Unfortunately, this is not my only matter that I have to work on.
And also, counsel, that you say that, let me ask this, because it may have been your intention, it may not have been. As I understand it, you had indicated to the people you were going to call this expert today.
I think he said he may call, yes.
Okay, May. Okay.
But I don't have to, and I won't. I just don't know how I could have my cross-examination curtailed by the fact that I got some information.
By what?
By the fact that I got information from someone who knows the topic. So, for instance, if this were like a skid mark case, the issue is how long was the skid mark? And if an expert told me, hey, ask them this question, and I came in and asked the question, that's not unfair, and that's not, the defendant has a right to cross-examine, as you know. And so I think that right.
It would, counsel, that's a very simplistic analogy to this, because I don't think this isn't just a skid mark. If it were just a skid mark, then okay, you could do that. You're actually talking about rather complex things that then have to be arranged in a certain way to come to some type of conclusion.
And there you have it. This wasn't just about one report. It was about timing, strategy, and fairness. The defense wanted the right to cross-examine fully, armed with expert insights. The prosecution pushed back, warning of unfair surprise. And the judge? He wasn't buying the skid mark analogy, reminding everyone that complex forensic evidence isn't as simple as measuring tire tracks. This case highlights a bigger truth. Courtroom battles aren't just about facts. They're about how, when, and even why those facts are introduced. So what's your take? Was the defense fighting for fairness or playing last-minute tricks?